Hi, this is Rahul Reddy. We're here live from Houston, Texas. As every week, we bring in live news about immigration every week on 5 Central Time Facebook Live. And along with me is EADD Neumann. She's my business partner.
Thanks for joining today, and please feel free to ask your questions during the live video, and we'll try to answer as many of them as we can. If we can't get to your question, you can always post it on Facebook, and we'll get back to you. You can, if you want more information, more detail, you can set up a consultation by going to rnlawgroup.com and selecting consultation. You can choose one of us or any of our other immigration attorneys who are happy to help you. You can also visit me at immigrationgirl.com. That's my blog where I write about practical tips from the desk of an immigration attorney. There I've tried to post the latest updates as they're happening and answer questions that will actually help you in your immigration journey. So we have lots of updates as usual. That seems to be the name of the game right now, is everything is changing. So one of the updates that we got last week was about the premium processing. So where do we stand on premium processing right now?
Premium processing has been suspended except for extensions. The premium processing is not going to be there for transfer cases. The premium processing is not going to be for amendment cases. The premium processing was never there for the quota cases because the premium processing was suspended starting from April 1st onward, so it was already suspended for the quota cases. We were expecting that the premium processing is going to be active on September 10th, but they said right now that starting September 11th also you will not be able to convert into premium processing. Emily, what are the consequences? How would people who are who don't want to wait, why do they don't want to wait? Why do they want a premium processing? And how is this one negatively going to affect clients?
Yeah, I mean, it practically affects every type of H-1B case except for the extensions without change. Those go to Nebraska and still can be filed in premium, or the cap exempt employers. So one of the questions I'm getting most commonly on the blog is, what makes it an extension without change? When can I decide to file in Nebraska versus filing in California or Vermont? So really they want to see an extension without change where there's literally no change in the employment based on what you filed 3 years ago. So the job title should remain the same, the job duties should be the same, the SOC code should stay the same, the wage should be the same, the work location, everything should be exactly the same in order to file in Nebraska. And that's based on what box is selected on the I-129 form. Now, are there some changes that you could make that still allow you to file in Nebraska? Potentially, but there's a risk that they could always say, no, this is an extension with change, we're not going to accept it. So you do have to tread carefully on that. Now, for those that are filing an extension with change, what does the suspension of premium processing mean? It's really critical for those. We've been talking about file early, file in premium for months
all the time
now, because we see so often people file too close to when their I-94 is expiring. While the application is pending, the I-94 expires, and then they end up with a denial. Once the denial happens in that situation, the denial puts you immediately out of status, immediately unlawful presence begins to accrue. There's not a lot you can do to get back into status without leaving the country. So for those that are just filing an extension with change, not having that premium processing makes it more likely that the I-94 might expire while you're waiting, so there's an added risk. We have the NTA Memo that might come into play anytime now. By the time that they get around to adjudicating your extension with change, the NTA Memo might be in play. So if you get a denial at that point, we don't know if an NTA will be coming along with it or shortly thereafter, so that's a huge risk. There's also risks for filing transfers.
Yeah.
So if you're filing a transfer, typically a lot of people prefer to wait for the approval before they join the new employer to make sure they're safe in transferring. Now, if it's going to take 4 to 6 to 8 months to get the approval.
Plus there is an RFE, you add 6 more months after that.
Right. Are people willing to wait that long to join the new employer? Probably not. And those that do join the new employer based on the pending transfer have that added risk where they just don't know if their petition is going to get approved. So For those that are filing transfers, it is a risk right now in order to file it in regular processing and wait all of that time or join the new employer based on the receipt. And then lastly, you have the cap subject to H-1Bs that were filed in the lottery.
Oh yeah, nightmare.
I think those are really impacted by this because normally those are starting on October 1st, yet we're seeing, at least 30% of the cases out there are still pending with no action taken at all. So it's very unlikely that they'll have them all approved by October 1st, which is really bad for cap gap individuals because they lose the cap gap work authorization on October 1st. Have to stop working and either exit the country or find a way to continue the F1 status while you're waiting for the H-1B to be adjudicated. So, amendments as well, we recommend not traveling while an amendment is pending. So a lot of times people will upgrade to premium processing in that situation. That won't be allowed either. So it's going to impact your ability to travel, your ability to change jobs. If you have filed your extension and your I-94 expires, you might not be able to get your driver's license renewed.
Yikes.
Here in Texas, they usually don't renew the driver's license based on a pending receipt notice. So it's going to be a huge impact between now to February.
And not to forget that for those, the student visa people whose status was being questioned, the August 9th memo went in that if they are out of status and if they are unlawfully present in this country for 180 days, that might affect. So if their H-1B does not get adjudicated until February 4th and they are adjudicated saying the person did not maintain the status, they might have a 3-year bar into coming into the United States. And for those people who are expecting to continue working based on their H-4 EAD because their spouse is going to file for the H-1B amendment plus extension or probably transfer to one company to another company, they might have a big problem because their H-4 EADs might not be approved because if the H-1 is not approved, the H-4 EAD will not be approved. So a lot of bad news for no apparent reason. Because why? Because the administration said they don't have money to raise the federal government salaries. Now these people are taking the money that some of the immigrants want to pay. They don't want to take that money. It seems that this administration wants to suffer the legal immigrants and probably promote the undocumented people. That's how I see this one. Because he wants money to build the walls while the immigrants want to pay the money here. He doesn't want to take the money.
Yeah, it's, they call it the invisible wall when you're talking about legal immigration. It's just how many obstacles can you put in the way? How many hurdles can you make towards legal immigrants to where at some point they either have to leave the country or they choose to leave the country and go elsewhere where their skills are wanted and needed more than they are here. So it's not going to be a great situation for the economy as we maybe are not going to be as competitive. We're not going to be the beacon where all high-skilled workers want to come anymore. That's going to limit innovation. This could have a huge impact. So hopefully we will at least start to see some premium processing come back before February. Do you think that's even possible?
It doesn't look like that. It looks like they have deliberately trying to suffer the immigrants only. It doesn't look like. I want to go some good questions coming from Sachin. When I go for the visa interview, is my Facebook and Twitter going to be evaluated?
It could be. So if you, not everyone is asked to fill out the enhanced review portion of the visa interview process where they ask for all of your social media handles. Some people are getting that and they do have to fill out that information. But if it's publicly available on Google, if I can Google
Twitter
your name
and, Facebook,
and I find your Facebook, I find your LinkedIn, I think they can use that information as part of the visa interview process.
The question is, Sachin also asked, is that if I would say something about HR 392, will it negatively impact my visa application? If you are on a H-1B, L-1 or some other visa which doesn't require a non-immigrant intent, if you comment on the Facebook or Twitter about the HR 392, I don't think so. Your visa will be rejected just because you commented on the HR 390.
Yeah, I think they're more looking for fraud or misrepresentation, where you have a petition sponsored by company A, but your LinkedIn shows that you're working for company B, or maybe you mentioned you had all this experience in your H-1B petition letter of support, but then maybe your LinkedIn doesn't show that experience, or shows you were living in a different country when you claim to have that experience. So I think it's more they're looking for misrepresentations or fraud versus punishing people for their political views.
Manoj has this question: can I file the H-1B extension and transfer at the same time? I'm assuming you're speaking with different employers, extension and transfer, extension with the existing employer and transfer with a different company. Yeah, we don't see any problem. That's not something considered as bad thing if you do both the companies and you do not know which one to choose. You want to choose the employer at a later time, that's not an issue. That may be an issue when you're filing the quota cases, because sometimes the employees want to circumvent the lottery process. That's the only reason why they are filing two applications. But in your case, we don't see technically any problem in filing both the things at the same time.
Shivani is asking if we've got any updates about that NTA memo. So since we know the memo came out and they directed all of the service centers to come up with their procedures for how they were going to start issuing these NTAs in the event of a denial that puts someone, makes someone unlawfully present. And then all of a sudden they came back and said, never mind, we're going to keep it on hold because we're not ready. Do we have any updates on it since then?
At this point of time, the USCIS have taken back the memo. They can always come back and implement that memo. However, I think so the people who are law-abiding immigrants in this country, I don't think so they should fear that much, Emily, because I don't think so administration is going after those people. Let's say, for example, they transfer from company A to company B and their transfer got denied. Would they get an NTA, notice to appear? Yes, there is a chance. But is the administration is going to go ahead and issue an NTA? Because it still is a burden for them. If they issue an NTA, it's going to cost a lot of money for the administration, because a lot of these immigrants are law-abiding citizens and law-abiding people. If they get a denial, they normally leave the country and try to come back into this country though. So I will be very surprised if they would issue an NTA when your change of employer or when your change of status is denied. However, if there is a pattern of violations, if it thinks where you already, when you file the extension or when you file the transfer, you're already out of status, yes, there could be a very good chance for issuing an NTA. I might be wrong on this, Emily. What do you say?
Yeah, it's a little unclear because the NTA memo didn't really say that they may issue an NTA. It said they will issue an NTA, which makes it sound like there's no discretion and they have to do it in every case. I think it will really be in how they implement it. Are they going to give a sufficient amount of time for people to leave voluntarily before the NTA is issued? And hopefully they will at least have the sense to allow for that. And they can't expect people who are here with families and high-skilled jobs are just going to be able to leave tomorrow. They've got houses, they've got cars, they've got pets, that they need to take care of before they can't just up and leave in the middle of the night.
Rakesh has this question: I have only one chance to file for a H-1B. Can I file with multiple employers at the same time? Rakesh, don't do that. We have seen a lot of employees getting into trouble because of that. I would recommend that you only file H-1B with one company. We have seen a lot of fraud in cases where companies are filing for those people who are not being employed at this point of time. They're not only filing an H-1B for you, they're also filing for hundreds of different people. And I don't know if they're collecting the money. That's another fraud thing. When they get into trouble, you will be in trouble. We have noticed that for those people who have applied in this fashion where there is no job, the company did file a not so good application, they got their H-1B approval, they moved on to company B. When this company got into trouble at a later date, that company will admit to get away with the lesser sentence, they will admit that they have done all these applications wrongly, then what will happen to you is that down the line, you will be in trouble. So my advice to you is that if you have a job, then only file it. And if you're not working for that company, if somebody is telling they're going to file a H-1B, don't believe them and don't file them. You will be in trouble.
Ramya has a common question that we're seeing right now. So her H-1B change of status is already approved. Now she lost her job. What are the options to transfer? Can she file a transfer now?
Is that a quota case or
yes.
is it?
Well, I'm assuming.
Yeah, if it's a quota case, if you filed a transfer right now, that's not a good thing. But if you already lost the job, it depends on if your company has withdrawn the H-1B or not withdrawn the H-1B. I would have the H-1B transfer filed on October 1st, Emily. If the company has not withdrawn the H-1B, I would file it on October 1st. I checked up, October 1st happens to be a working day, so that's good that you can file it on October 1st, because at that time you could say that you're not working for that company, but you file a transfer, and you don't need a paycheck from that company which filed for the H-1B.
So just to review, are there any ways after September 11th to file an H-1B transfer in premium processing?
No. You can't file in premium processing after September 11th unless the USCIS changes its opinion and they will issue a new notification that you can file for the change of employer. You could file in premium processing, you cannot. Under limited circumstances, you could file an expedited processing, not a premium processing, but I would say those limited circumstances are very rare. For example, if you are the pilot who is driving the NASA satellite from California to Florida, and you are the only pilot who can ride that airplane on which the rocket sit, and that can only be transported at a certain time, I think so that's an exception that I would take it. There are certain scenarios where there's emergencies, but I'll be very surprised that the USCIS will just grant the exception and transfer the H-1Bs just because you need to join, you need to leave the country. Those are not acceptable reasons. There's something real emergency, they will accept it.
Do we have any update on the H-4 EAD?
Good thing. No update on H-4 EAD. We said that in June 2018, the USCIS is going to come with the new proposed regulations. As of today, which is September of 2018, no proposed regulations were being published. So at this point of time, if you're eligible for H-4 EAD, you could file for H-4 EAD. You could file for H-4 EAD extension. Absolutely no problem. When and if there is a H-4 EAD proposed regulation comes in, we do expect that it's going to take a long time for it, maybe between 3 months to approximately 12 months for that to go into effective. So in the interim period, you could probably be still filing the H-1B, H-4 extensions and also H-4 EAD, H-4 EAD extensions and H-4 you could. So there is not much to panic at this point of time. You also, if you ever had a H-1B before and now you are on H-4 EAD, I would not hurriedly convert into H-1B at this point of time. When and if the proposed regulations come in, at that point of time, I would consider converting back into H-1B.
We have another memo coming up, which is the
Yikes.
RFE memo. So that memo says that after September 11th, if you file any kind of immigration application, if there are required documents that are missing, they can deny the application without issuing an RFE and giving you a chance to submit those documents. So do you think, number one, are they going to apply that to CAP cases that are already pending?
One, Emily, is that the CAP cases were being filed before September 11th, so that's completely not applicable. As you said, the memo is effective on September 11th, and it's actually saying that any applications filed on or after September 11th will be considered under that. Now, I'm going to ask you a couple of more questions on the same line, Emily. Do you think so that, we have seen that the RFE rates have been increased for a lot of the non-immigrant visa applications? Do you think so that there is not going to be any more RFEs for the applications filed on or after September 11th? Or is it it's going to be a flat denial, no RFEs?
Well, I'd certainly like to see fewer RFEs, but I don't think that's the case. They will still issue RFEs. The only situation where they're just going to deny it straight out without an RFE is if some required initial piece of evidence is missing. So it's got to be a pretty major document.
So what is a major document? For example, if it's a L1, what is the required piece of information that you think so is essential to file along with the application, without which they may strictly deny without issuing an RFE?
Yeah, I mean, you've got to have the filing fees, you've got to have the I-129 forms, you should at least have a employer letter of support that explains either the specialized knowledge or the manager or executive nature of the position abroad, the position in the U.S., and probably some sort of documentation regarding the qualifying relationship between the two companies. Now, if you provide some document of the qualifying relationship and they want more, they'll still issue an RFE for that. So I think that the basic documents that people would normally file should be
Emily,
enough.
we have been receiving RFEs even though when we submitted all these documents that you said, historically we have been receiving RFEs. So what difference is this memo going to make?
Yeah, I don't think it will make much difference for the vast majority of applications and petitions. It's really meant to weed out the applications or the petitions that really have no merit at all. Right now, if someone files an application completely incorrectly, they're going to send a request for evidence to give you the opportunity to fix the problem or prove how you qualify. So those are the types of applications they're trying to weed out, which would hopefully improve processing times because they're not going back and forth on applications with little to no merit.
Now, when it comes to the H-1B though, now some of these people are working at third-party location. What are the essential documents that you feel that the USCIS might not issue an RFE starting from September 11th? What are the documents you feel that after September 11th still they will issue an RFE? Of course, all this is a guessing game based on our experience. We might change our opinion, but what is the things where you think so that essential documents, what do you think so that optional documents which they're going to issue an RFE if they don't like it?
Yeah, I think required documents would be the I-129 form, the LCA, education documents, education evaluation if your degree is not from the U.S., a letter of support from the company explaining the specialty occupation nature of the position, and if you're already in H-1B status, proof of maintenance of status, which would typically be pay stubs and a W-2. Beyond that, I think the itinerary, if the petition is filed in a way that requires an itinerary, it should be submitted. I think that if the job is one that requires a license, like a professional engineer or something like that, you need to submit the license at the time of filing. I think, anything beyond that is, it's a guessing game, but I think they will still issue a request for evidence for additional documents, especially in the situation of third-party placement. Of course, I would provide everything I can to minimize the risk of one of these denials without an RFE, but I think that they'll still issue RFEs in the majority of non-frivolous filings.
Ashwin has this, his client letter has shed its 3 years of employment. He only got 10 months of the approval. Can I appeal or open a service request? It's not just the end client letter that will determine the period of time for which you get the H-1B. There are multiple factors that will be taken into consideration. What about the statement of work? What about the MSA? What about the vendor letter? What about the contract between the vendor and the end client? How much it says? If the end client just issues a 3 years, but if the SOW, statement of work, says differently, then the USCIS is going to take whatever is the shortest period that is there. So I would be careful in looking into documentation to see if any of those things were being given 10 months. That's probably the reason why you got H-1B approval for 10 months. Have you seen any shorter duration of H-1B approvals, Emily? Is there any H-1 approval where you have only seen 3 months, 4 months?
Yeah, it does happen from time to time. I think it's the exception and not the rule. We're still getting 3-year approvals. So it really just depends on the officer.
But can we challenge the officer, or can we challenge the decision made by the USCIS if it's a shorter period of time?
I think that's tough because typically an appeal situation is where you've received a denial. So we haven't received a denial, they just didn't approve it for as long as we requested. So it's questionable whether that can be solved by filing an appeal or some sort of lawsuit. Maybe a service request if you've got supporting documents to show that it should have been extended for longer, but without premium processing, those service requests probably are going to take at least 30 to 60 days. So you might end up having to file the extension anyways based on the originally approved end date.
Mohammed has this question that can my wife file a H4 extension application while my H1B is still pending? My lawyer said that my H1B has to be approved before the H4 can be applied. The answer to your question is H4 can be applied while your H1B is pending. You don't need the approval. When you file for the H4 extension, you could take a copy of the receipt notice of your H1B approval and seek the H4 approval until the expiration date for which the underlying H1B has been applied for. When they adjudicate the H4 application, they will look into, because everything is database right now in computer, they look into the H1, whether it's been approved or not, if it is approved, until what period it's been approved, and they will grant the H4 visa until the period for which you actually got the H1B approval, even though it was not approved on the day of filing for the H4 application.
All right, 2 questions on pending applications after an I-94 is expired. So say the H1 extension has been filed or an L1 extension has been filed and it's pending and now the I-94 is expired. How long can that person stay in the country? How long can they work?
They can stay here until the decision is been made, or depends on, for example, if they are asking for the H1B extension only for 1 year, and if the decision does not come until 1 year, you can only stay until 1 year. So it's either until the decision is made or the expiration of the H1B, underlying H1B you are being asked for, whichever is the later, you can stay until that period of time. Now, of course, there is a 240-day rule for the H1B extension, is that when the extension has been filed, you can only work for 240 days. You cannot work beyond the 240-day rule. That rule after the expiration of the I-94 is only that you cannot work beyond 240 days, but you can stay after the 240 days. Also, you can stay in this country. Emily, why are these people waiting? Because why can't they file in premium processing? They are still allowed to file in premium processing, is right?
Yeah, I mean, if you have your application already filed and pending and you're afraid your I-94 is going to be expiring soon, you can still upgrade to premium before September 11th. It doesn't take that long to get that application prepared and filed. So that's definitely something to consider. Now, what about how does your answer change if it is a transfer versus an extension with the same employer?
If it's a transfer, there is no 240-day rule. You can continue working. You can continue working until the requested time has expired or until the transfer has been denied. Not only that you can stay in this country, you can continue working.
All right. What circumstances would allow someone to file a change of status from F1 to H4 and stay in the country based on the pending application?
From F1 to H4, if their spouse is on H1B, you could apply for F1 to H4 visa. And if you are allowed, if you're permitted to work based on your student visa, until your H4 is approved, you can continue working. It will be your option. If you want to stop working on the day you file for the H4 with the start date effective immediately, you can. Or you can continue working if your student visa allows you to work until your H4 has been decided. A lot of times where they are in doubt right now, when they have filed from F1 to H1, whether their H1 is going to be approved or not, what we're telling those people is go ahead and apply for the H4 anyway before your status expires, so that if just in case your H1B gets denied, you can stay in this country legally and you can get your H4 approval.
One of the top questions we're getting right now with premium processing ending in a week is how long does it take to get an LCA so that I can file my H1B transfer in premium processing?
What's today?
Is it too late? Today's the 4th, so
Today's
I don't
the
think
4th.
it's
Its time is over. It's 5 o'clock, so it's going to be 5th. So by the time the LCA gets approved, it's going to cross September 11th. It looks like.
It usually takes 7
And
days.
it's actually September 10th. Actually, the USCIS has to receive the application on September 10th. So if you file an LCA right now, you're going to miss the deadline. That's our expectation, though.
Yeah.
If you have already filed LCA, then there is a chance for it. Now, for all those people whose H1B amendment and the transfer of the H1B is pending, you have still time to go and file the premium processing until September 10th.
Yeah, so just to recap on that, premium processing is available all the way up through September 11th, so you can file an application in premium processing now. You can upgrade a pending application to premium processing now. After September 11th, you can file an extension without change with the same employer in premium processing. Everything else needs to go in regular processing except for cap exempt employers.
Vishruth has this question. I'm now wanting to work from my home, and since it's not in the same MSA, my employer is filing an LCA. Does the employer need to file an amendment because Vishruth going to only work from home?
I think it depends on the MSA, what
It's
area.
a different MSA.
Different MSA, an amendment is required.
Amendment is required. Now, if it's the same MSA, actually, you might not require an LCA at all if you're working from home. So if your company location and your location, your home location is within the same MSA, you don't need to file an LCA. If it's a different MSA, you need to file an LCA. The amendment requirement, what the matter of Simeo, the Administrative Appeals Unit said, is that when you are filing a different LCA, they want to have an amendment. So they are filing a different LCA because it's a different MSA. So that's why it needs to be amended. The USCIS, or most of the world governments at this point of time, does not recognize cyberspace as a space at all. I don't know if any country recognizes, but USA does not recognize cyberspace as a space. So if you're staying at home and you're logging into the computers in very different location and you're working, you will be considered to be working at the place where you're sitting at. You will be subject to the taxation, state taxation, all the different taxation at the place where you're sitting at. So here, since you're working at home, they will consider that as a workspace, and since it's a different MSA, you need an amendment.
So I want to go back to the lack of premium processing for F1 students who are waiting for their change of status to get approved, and how does that interplay with the August 9th unlawful presence memo?
Yes, you need to be very careful on this August 9th memo. What is the August 9th memo? Unlike the September 11th memo and the NTA memo, was that this August 9th memo was specifically issued for the student visas. Most probably many of them are F1 visa. It's also applicable to some M visas, but the most effective thing is the F1 visa people. What does this August 9th memo says that if you are undocumentedly present in this country for more than 180 days, you have a 3-year bar. Now that's not in the memo, but I'm telling you, in general, the IRA law, which became effective on April 1st of 1997. I remember the date so clearly. It became effective on April 1st, 1997, because our law firm, REDDY NEUMANN PC, formed and became effective on April 1st of 1997. Then it was called the Office of RV Reddy, and at that time, so IRA law says that if you are undocumented present here for 180 days, you have a 3-year bar to enter back into United States. If you are present in this country for 360 days, you have a 10-year bar to come back into this country. Though this memo does not say anything about the IRA, 180 days and 360 days of unlawful presence, what this memo says is that the day you started violating the legal status on F1 visa, that's when the unlawful presence will count. Now, previous to the August 9th memo, if the status was being denied because the student violated, the unlawful status would have been counted since the day of the denial. It doesn't go back to the day a person violated the legal status. Now this August 9th memo completely changes the whole scenario, making a lot of people barred for 3 years or 10 years. So in light of this August 9th memo, since there is no premium processing for the student visa, if the adjudication of the status takes beyond February 4th of 2019, because if a person violated the status before August 9th, the unlawful stay will still count from August 9th based on the memo. So 180 days from August 9th will be somewhere about February 5th or February 4th of 2019. If the premium processing, since the premium processing is not allowed, if the status is denied on or after February 4th and you want to leave the country, you will have a 3-year bar on you. And if it is 360 days, you will have a 10-year bar on you. So if there is an RFE that is asked about the status, whether it's a STEM extension, whether it's a CPT that you really were in status, and if that is denied, your chances of coming back on that H-1B will be almost nil. And that's the reason you need to be very careful. If the status has been an issue in the RFE, you need to be very careful. If you want to answer, I would recommend that you contact a very competent lawyer who knows the laws very carefully and try to choose, because there are ways to avoid addressing those issues. In the cases where the person has been in CPT, they have done a master's degree, they have taken the OPT, they have done the STEM extension, now they have gone to CPT. The USCIS is questioning, how come the university is issuing a CPT? If they deny it, you will have a 3-year bar. And this premium processing suspension have a very detrimental effect on the people. I would want you guys to be very careful if you have an RFE on those issues. And on the STEM extension issue that I want people to be aware of course, we have had in early part of 2018, the USCIS said you cannot work at third-party site, and based on the litigation that we are one of the architects of the litigation, is that now they updated the website saying that yeah, you can work at third-party site. Does that mean the person can work at the third-party site without any limitations, or is there a limitation on how they can work at third-party site?
Yeah, not all third-party placement is going to be enough to meet the requirements of the STEM OPT extension. So if you are working at a third-party site during your STEM OPT, there must be a bona fide employer-employee relationship, and the employer must actually be providing the training to you as they mentioned in their I-983 form. So those are typically the items that are going to be requested in a request for evidence from USCIS about the change of status for you to prove that you maintained your status. So just because USCIS came out and said, yes, we think you can work at a third-party site while you're on the STEM OPT, does not mean you're 100% in the clear if you've got that type of RFE. You still have to be able to prove the bona fide employer-employee relationship and that the training plan has been complied with during the STEM OPT time.
One of the questions that was raised here is, Vartika, was that, can I look into Wall Street jobs on a H-1B? You could, but there are some issues with the financial and management and the MBA degrees right now as compared to the 2016 though. Now, it's not how high you get paid, it's not how high your position is, it's how specific your position is. Just because you're a super manager or making $200,000 or $300,000 does not make your H-1B better though. Sometimes it's more specific the position is. So especially if in a software profession you're going into the very detailed software profession, that probably has a better chances than the manager, because managers sometimes might not require a specific degree, but the software developers might require a specific degree. So it's not whether your job is high or low, it is how specific it is. Let's say, for example, in a Hilton hotel, the Hilton hotel manager, the manager of the whole Hilton hotel might be a higher level. But if there is a job as an accountant in the Hilton hotel, the probabilities for the accountant to get a H-1B is much higher than Hilton hotel manager, because normally accountants, specifically the high-level accountants, require accountant degree, but Hilton hotel manager might not require a specific degree. Now, when it comes to the L1A, it might be quite different story, because Hilton hotel manager has a better chance. But when it comes to the specialty occupation for H-1B, the specific position is more likely to get the H-1 approval comparative to the higher level positions.
All right, I think we have time for one last question. Vijaya just popped in with a good question here. In this day and age of H-1B extensions getting denied, what happens if the H-1B extension is denied before your I-94 expires?
Wow, that's a cool option. If your H-1B gets denied before the I-94 expires, you have an option of filing the H-1B extension again with the same company. You have an option of choosing a different employer to file a H-1B transfer. These are the two. And if you are eligible for H-4, that's another option that you can choose to move into. That's the reason why Emily has been advocating a lot from the beginning to file a premium processing, get the decision before the I-94 expire. Now, as I said, Emily, that they have an option of filing an extension with the same company again. They have a chance of filing a transfer with a different company. They have a chance of moving to H-4 if that option is there when the I-94 has not expired. Now, in the same scenario, when the I-94 has expired, what will be their situation?
Yeah, from the day of the denial of an H-1 extension after the I-94 expired, you're immediately out of status and immediately accruing unlawful presence. Once you have both of those, it's almost impossible to get back into status. So your only option typically is going to be to exit the country. Now, from there, an employer may sponsor you for an H-1B while you're outside the U.S. It's going to have to be in regular processing, so it's going to take 6 months, and you're stuck outside waiting. So the chances of moving beyond a denial and continuing your stay in the U.S. are much higher if that denial occurs before the I-94 expires. And to answer the specific question, yes, you can continue working until the I-94 expires, even if your extension gets denied.
If the H-1 extension has been denied, the I-94 is still valid. Can they still continue working?
Right, yeah, as long as the denial was not related to a status violation, they should be allowed to continue working to the end of the validity period.
Anything else?
I think that's about it for today.
Thank you for the comment, Rajan. The things we too are beyond awesome. Thank you. We take the comment very good. We would like you guys to like us and subscribe to our news channel, and also please give any comments that you have. We appreciate that. Thank you very much for coming in live. Thank you, Emily.
Thanks for joining.